Legal rights of the disabled in India. Education law for the disabled. The right to education is available to all citizens including the disabled. Article 29(2) of the Constitution provides that no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on the ground of religion, race, caste or language. Article 45 of the Constitution directs the state to provide free and compulsory education for all children, including the disabled, until they attain the age of 14 years. No child can be denied admission into any education institution maintained by the state or receiving aid out of state funds on the ground of religion, race, caste or language. Health laws. Article 47 of the Constitution imposes on the government a primary duty to raise the level of nutrition and standard of living of its people and make improvements in public health, particularly to bring about prohibition of the consumption of intoxicating drinks and drugs which are injurious to one's health except for medicinal purposes. The health laws of India have many provisions for the disabled. Some of the acts which make provision for health of the citizens including the disabled may be seen in the Mental Health Act, 1987. Family laws. The rights and duties of the parties to a marriage, whether in respect of disabled or non-disabled persons, are governed by the specific provisions contained in different marriage acts, such as the Hindu Marriage Act, 1955, the Christian Marriage Act, 1872 and the Parsi Marriage and Divorce Act, 1935. Other marriage acts which exist include the Special Marriage Act, 1954, for spouses of differing religions, and the Foreign Marriage Act, 1959, for marriage outside India. The Child Marriage Restraint Act, 1929 as amended in 1978 to prevent the solemnization of child marriages also applies to the disabled. A disabled person cannot act as a guardian of a minor under the Guardian and Wards Act, 1890 if the disability is of such a degree that one cannot act as a guardian of the minor. A similar position is taken by the Hindu Minority and Guardianship Act, 1956, as also under the Muslim law. Succession law for disabled. A disabled person can also dispose his property by writing a will, provided he understands the import and consequence of writing a will at the time when a will is written. Even blind persons or those who are deaf and dumb can make their wills if they understand the import and consequence of doing it. Labor laws for the disabled. The rights of the disabled have not been spelt out so well in the labor legislations, but provisions which cater to the disabled in their relationship with the employer are contained in delegated legislation such as rules, regulations and standing order.